all about highways. Our speaker is Lori Miffin-Damasi from the Association of Towns of the State of New York. Lori received her undergraduate degree in communications from Ithaca College and her law degree from Albany Law School. She has been a member of the Association of Towns legal staff since 1993, where she provides training and legal assistance to town officials and works with the legislature and the state agencies to improve town governance and efficiency. The Tug Hill Commission would like to thank Lori for agreeing to do this session tonight.
Oh, it's my pleasure. Thanks for having me.
Please use the chat feature to ask any questions you have, and we will get to them either during the presentation or at the end. We hope you find this presentation informative, and with that, I will turn it over to Lori to get the webinar started.
Thanks, Jean. Good evening, everybody. I wish I could be with you in person, but it's nice to be with you virtually. It's been raining here today in Albany. I don't know what the weather's been like where you're watching this webinar from, but I hope it's been a nice day for you. So let's get started. My focus tonight is going to be on town highways. If you happen to have a village, city, or county question, I can certainly try and get you some information afterwards, but I just wanted to put that up front that this is mostly going to focus on town roads. So we're going to talk about a lot of frequently asked questions that we get here at AOT about right-of-way management. And we'll get started with the most common types of roads that towns have. So towns can establish town roads in a variety of ways, but the most common ways that towns establish town highways would be through a dedicated highway program, accepting streets and subdivisions, or highways by use. So we'll start with dedicated highways. The source of authority that you're going to need to review is Highway Law Section 171 when you have a question about the authority or the procedure with respect to dedicated highways. This is where private property owners who are abutting to usually a private right-of-way wish to have the town take over their private road as a town road. And so they will come to the town and they'll offer it for dedication. They will usually approach the highway superintendent first. In order for the town to accept a private road by dedication under Highway Law 171, it requires both the highway superintendent's consent and also the town board's consent. And the town board would provide its consent by the adoption of a resolution at a board meeting. Under the highway law, the county highway superintendent will provide a survey for the proposed right-of-way, and that would be included in the highway superintendent's order establishing the dedicated highway. The width is supposed to be 3 rods, and that's from ditch to ditch, and the survey should show what we're talking about and what road, what property might need to be added to get the right-of-way to 3 rods. If you're looking at something less than 3 rods, you will need to reach out to your regional DOT office to see whether or not they can consent to establishing a new right-of-way at less than 3 rods. It's preferable if the owner provides a deed, and that deed is then recorded in the county clerk's office so that there is a clear chain of title so that everybody knows that this is a dedicated and now town right-of-way. Because this is a dedication, usually it's at no cost to the town, and the town can place reasonable conditions on its acceptance. So if the right-of-way is not in a very good condition, or it doesn't meet the town's road standards, which we'll discuss in a little bit, the town can require that the abutting property owners improve the road to the town's standards before the town will accept the right-of-way for dedication. If it's an insurmountable cost for the abutting property owners, there is a mechanism in the town law under Section 200 to create a temporary highway improvement district of sorts, where the town can take over the substandard road and then charge the cost back to the abutting property owners to upgrade the road. Any maintenance going forward, snow removal, ice removal, improvements, would then be a town highway charge. Okay, another type of dedicated highway is in subdivisions. And this is found under Article 16 of the town law. Section 279 deals with streets and subdivisions. So generally how this works, the developer files an approved subdivision plat in the county clerk's office with an offer for dedication of the subdivision streets. The town board has to accept the offer for dedication by board resolution. If the board doesn't accept the offer for dedication, then the offer for dedication can remain open until such time as the developer chooses to revoke it in the future, if ever. Statutorily speaking, the highway superintendent's consent is not required under Article 16 of the town law, like it is under Highway Law Section 171. Your town code, however, may have a highway superintendent consent and may direct that the highway superintendent work with the planning board and the developer, and maybe the town engineer, if you have a town engineer working on the project as well, to come up with a plan to make sure that the highway system, once dedicated and accepted, can be suitable for town highway operations, most commonly snow plowing. And you also want to make sure that there's a clear, in both of these circumstances, there's a clear requirement that that the property owners, either in the subdivision context or in the individual dedication, that they are expressly dedicating this, because anytime that it's not dedicated expressly, then you might be looking at a highway by use situation, which we're going to discuss in just a minute. So once you've got an established dedicated highway, there may become a point in time when the town stops using that highway and it needs to be discontinued. And so there is also a procedure in the highway law to discontinue dedicated highways. It requires a written application from the abutting property owners to be filed with the highway superintendent. Again, you need a town board resolution consenting to the discontinuance. The highway superintendent has to determine that the highway has become useless. And this is a question of fact. There are some court cases that give us some factors for the highway superintendent to consider. Sometimes these issues do wind up getting resolved in court, but it's for the highway superintendent to make a first pass determination. And some of the things that the courts have suggested the highway superintendent take a look at would be, what are the conditions of the road? What's the population that's served by the road? Is the road providing access to schools or markets or businesses or places of worship? What are the physical features of the area? What's the topography and the soil conditions? And so those are things that the highway superintendent, that the courts have said, should take a look at when making a determination whether a dedicated highway has become useless. There'll be a release of all damages that have to be obtained from the affected property owners. The statute dictates conditions that are to be paid for release of damages. So the abutting property owners will be entitled to a fee from the town under the highway law. Once all of this is done, the highway superintendent files an order of discontinuance in the town clerk's office. And that should be filed with all of the consents and the releases. And then the town clerk records the releases in the county clerk's office. And then once this all finishes, then the property can be transferred or sold in accordance with Town Law Section 64, Subdivision 2, which requires a board resolution subject to permissive referendum. Most commonly, it's probably going to be one or more of the abutting property owners that would be interested in that property. So as we had said, if there is a problem with a dedicated highway, another way a highway could be established is a highway by use, sometimes referred to as prescriptive highways. And in some circumstances, most of your roads may fall in this category. The source of authority for this is Highway Law Section 189. And although the statute has changed over the years in terms of the requirements, the current requirements to establish a highway by use provide that it has to be 10 years of continuous and uninterrupted use by the general public, 10 years of work by the town highway department. There are court cases that have found sporadic snow plowing or occasional maintenance is not sufficient to demonstrate the required maintenance from the highway department to establish a highway by use. The width is supposed to be under the statute 3 rods, which is roughly 50 feet. But there's a body of case law that provides that the width for a highway by use is determined actually by the use itself. It includes the shoulders, the ditches, and the traveled rights of way. It may be in actuality less than 3 rods. If you want to open it up to 3 rods, you'll need to get authorization from the abutting property owners. And if it's a safety necessity that you actually open it up to 3 rods and you can't secure authorization from the abutting property owners, you may be forced to look at condemnation. So again, sometimes, even though we've established a town highway as a highway by use, it may be at some point in the future that it's no longer used as a town highway. So there's 2 ways that a highway by use can be abandoned. Dedicated highways are discontinued, highways by uses are abandoned. First, we're going to talk about total abandonment. This means that there's 2 different ways that a highway by use can be totally abandoned. First, it hasn't been opened or worked for 6 years after it was dedicated, or it's not traveled or used as a highway for 6 years after it was established as a highway by use. Highways are deemed abandoned by operation of law. So unlike a dedicated highway being discontinued, here, if the highway meets the fact pattern, the courts have said that it's abandoned by operation of law. There are still some administrative components that we need to comply with. You need a town board resolution recognizing that the highway by use has been abandoned. And the highway superintendent is required to file a certificate of abandonment, which includes a description and the town board resolution consenting to the abandonment in the town clerk's office. Although the abandonment happens by operation of the fact pattern and Highway Law Section 205, it's important to do those administrative steps because this begins the statute of limitations if somebody wants to challenge whether or not a highway by use has been abandoned. And they have 1 year from the date that those administrative functions have occurred. In the case of abandonment, total abandonment, the title reverts back to the abutting property owners and the public loses its right to utilize that highway by use. So again, with a dedicated highway, it can be discontinued as a highway, but the town still owns the property because the property owner had filed the deed with the town, and it has to be transferred through a process under the town law. Here, because the town never owned the property, it just reverts back to the abutting property owners. The second way that you can abandon a highway by use is referred to as qualified abandonment. And the same statute would apply. It's Highway Law Section 205. It's a different category or standard for qualified abandonment. Here, instead of not using or not working on it, we're looking at a standard of an average of 2 cars or less are using it daily, or pedestrians, or folks on horseback over a 2-year period. Here you also need a town board resolution and you need highway superintendent consent. And here, unlike a total abandonment situation, the county highway superintendent has a statutory role in this process, whereby the county highway superintendent holds a public hearing, has to provide written notice 20 days in advance of the hearing to the occupants and owners of the abutting property. And the purpose of the hearing is to determine if anybody will be harmed in the event the road is qualifiedly abandoned. In the event the highway superintendent determines that no one will be harmed and the qualified abandonment proceeds, the highway superintendent again files a certificate of qualified abandonment in the town clerk's office. Here, the effect is slightly different than total abandonment. Under a qualified abandonment, the town is no longer responsible for maintenance or care of the right-of-way and no longer liable for maintenance or care of the right-of-way. The public, however, still has a right to use the road. A totally abandoned road, it just reverts back to the abutting property owners. Here, the public still has a right of travel, but the town is no longer responsible for maintaining the right-of-way. The abutting property owners do have the authority under the statute to place an unlocked gate, and the purpose for there would be for farming and for pasturing. Okay, so we've established some of the most common ways that towns create roads or accept roads. So now that you've got a road and you're not going to abandon your road, it's important that we take care of our roads. And so now we're going to convert over and talk to road maintenance. Okay, so under the highway law, it's the highway superintendent who is responsible for the care and supervision of all town highways and bridges. And this responsibility includes basic things like inspections, keeping them in good repair and free of snow and ice, removing loose stones and other debris that might be in the right-of-way, along the sides of the right-of-way, keeping them clear of noxious weeds and brush, You want to inspect for dangerous trees and branches, and you want to keep the culverts and drainage passageways in good repair and open. Why is it important to do all of this? For the safety of the traveling public and to maintain our infrastructure. The courts have essentially said it has long been established that a governmental body, be it the state, a county, or another type of municipality, is under a non-delegable duty to maintain its roads and highways in a reasonably safe condition, and that liability will flow for injuries resulting from a breach of that duty. So we want to make sure that we are properly taking care of our roads. If you're ever concerned about a liability question, I always suggest that you should talk to the town attorney's office and also to the town's insurance carrier, because they may be called upon to step in the event you get a notice of claim filed if there is an accident or property damage. So we want to make sure that we're properly maintaining our road. And on the liability front, we can take a look at adopting a local law to require prior written notice. It's commonly referred to sometimes as the pothole law. So under the town law, you will have responsibility for potholes and other issues with the right of way if you have constructive knowledge. So you should have known about this. But we can adopt a local law requiring prior written notice, so that an individual needs to file, whether it's a person or a company or whomever, needs to put the municipality on written notice that there's a pothole on such and such a road. And then the town has the option, well, the responsibility, I shouldn't say option, has the responsibility to check it out and to put a plan in place to improve and address that pothole. And the courts give you a reasonable amount of time to address repairing whatever is in the written notice. So it's really important that we do that, because if not, you're going to be held to a constructive notice standard under this town law. And if you need copies of prior written notice local laws, we're happy to provide those to you. There is one exception, even if you have a prior written notice local law, and that's if the town has created the hazardous condition itself. With respect to road designs, we're going to talk about that now. Road standards and designs. So I am not an engineer. I want to put that right out there. I'm a lawyer. Cornell Local Roads, they are staffed with engineers, and they're a wonderful resource. I direct people to Cornell Local Roads website all the time. If you have any questions about highway issues, they have lots of great information there, including information on how to adopt road standards. And they recommend that they be adopted by professional engineers, reviewed by the town attorney. You should do it by local law. You can classify roads by volume, type of vehicles, land use, and seasonability of use, determining existing conditions of pavement, roadside signage. Signage does have to be in accordance with the Uniform Traffic Control Manual. Drainage and alignments, identify what needs to be done to meet adopted highway standards, rank the needs and prioritize the work to be done, develop and implement an action plan. And I've given you a link there on the slide so that if you want to check this out yourself, you can just go to that website. So same with road standards for just another moment. In terms of liability, you will be held to the standard of road construction when the road construction, or when you established the road. So it's a best engineering practice for when you established the road. But I caution, liability is very fact specific, and a town could be found partially liable, if not wholly liable, depending upon the facts and the circumstances. So you want to make sure, again, whenever there's an accident or property damage or notice of claim filed, that you're talking with your town attorney's office and with your insurance provider. There is an exception. You want to make sure that you've done this. You've got reasonable road design decisions coupled with no evidence of accidents on that right of way. So when you get a lot of accidents on a right of way, you want to go out and take a look at it, bring an engineer with you, see if a road redesign or a road course correction is necessary. And you want to make sure that you've documented everything and that you're keeping good track of this. And then just one more point on the liability front. For snow plowing services, if an individual is plowing the roads and they're doing so in accordance with their municipal function, they are exempted from the vehicle and traffic law basic rules of the road. And unless they are found to be in reckless disregard of public safety, you're probably not going to be facing liability there. And again, as with any liability question, these are all very fact specific. So we've got our roads, we're maintaining our roads, we're establishing standards for our roads. How do we preserve our roads? Lots of people want to use our roads, and sometimes the people that are using our roads can cause road damage. Roads are maybe not designed for that type of usage. And so there's a lot of options in the vehicle and traffic law for how to preserve our roads. You can establish, and these are all done by local law, you can establish a system of truck routes. You can exclude certain types of trucks from specified roads. You can exclude certain types of trucks by weight, length, height, or hours of operation on certain types of roads. If you have somebody who's using your roads in a manner that they're not intended to be used, and it's causing damage to your roads, there is a system under the highway law to recover the cost of restoring your roads. And if it was found to be intentional, that individual could be subject to treble damages. This would be done with the highway superintendent, and it would be a litigation brought in the name of the town with the town attorney's office, the town board, and the highway superintendent. And you can get treble damages if the court finds that the individual was intentionally using the road in a manner in which it was not intended to be used. We can also do temporary weight limits. This is often done coming up this time of year. You've got the spring thaw that's starting to occur in some areas of the state and will be occurring soon. This is also a local law where you can limit vehicles over 4 tons from using your right-of-way. Requires the sign to be, it requires signage, proper posting. All of these require proper posting. It requires a notice in the newspaper. And then an individual can apply to the town board for a local delivery permit exception. We have information on this. If you'd like any samples on any of these, we'd be happy to provide those to you. And Cornell Local Roads has also done a very nice comprehensive local law that you could take a look at on their website as well. Another option that folks were looking at and continue to look at is under the municipal home rule law. Here, it's a comprehensive road preservation local law, sort of encompassing all of these various options under the vehicle and traffic law. Or some towns are entering into road use agreements. These are voluntary. There's no statutory mandate that these be utilized, but some towns have found that they are helpful with respect to if they know there's a particular company that's using the right-of-way in a manner that the right-of-way is not designed to accommodate. They can go out and do a check of what the standard of the road was and condition of the road was before the usage began, and then enter into a road use agreement. This is again something that you're going to want to work with your town attorney's office on. We do have some sample agreements that other towns have used. To my knowledge, these have not been challenged in court, at least not in a reported court case. Okay, low volume minimum maintenance roads. We had talked about road standards and developing road standards. One type of road standard is volume and usage, and it's commonly referred to as minimum maintenance. I'm in the Tug Hill region. Everybody is very well acquainted with this type of road, and we're just going to go over very briefly what they are. So this was an idea that was originally discussed at the state level in the 1980s and the early 1990s. The state formed the Local Road Classification Task Force, which was then shifted into the Local Roads Research and Coordination Council. And the purpose of this was to study rural roads and whether there was standards or conditions or engineering practices that would be different for rural roads than more urban or suburban roads because of the usage of the roads. And they originally released guidelines for rural town and county roads. These guidelines are based on locally adopted low volume minimum maintenance road programs. There has been legislation introduced pretty much annually since this concept was originally discussed. The latest legislation is Senate 3825, Assembly 326. These bills are currently sitting in the Senate and the Assembly Transportation Committees, and they have not yet advanced this session. And there may be amendments forthcoming on those. It's early in the legislative session. So a low volume minimum maintenance road has to be done by local law. It's not currently outlined in the highway law like other types of roads are, and that's the purpose of the legislation, is to codify these practices into state statute. You can get sample minimum maintenance low volume roads on the Department of State website. Most local laws, I think for the last 20 or so years, have been posted on this website, and it's very user friendly. You can check by type of municipality, you can check by individual municipality, and they have a search query function. So it's a very useful website to check out if you're ever looking for sample local laws on anything, and low volume minimum maintenance roads would be there as well. The Tug Hill Commission has done a lot of great work in this area, and they have a wonderful report on their website. I would encourage you to check it out if you are not familiar with this issue or you're looking for more information on this issue. And Cornell Local Roads also has information. They have guidance that they make available when you're developing or looking at a low volume minimum maintenance road. So generally speaking, a low volume road is 400 vehicles or less. They have 6 categories. You can see them listed here from low volume collector down to recreation land access. Again, it's established by local law. And so the local law generally has various components, establishes a procedure to designate a low volume road, establishes a procedure for how to develop standards for the low volume roads, establishes a procedure to designate or discontinue low volume roads as minimum maintenance, and establish a procedure for development of maintenance and construction standards for these types of roads. Minimum maintenance roads are a subset of low volume roads, and they're generally associated with agricultural or recreational land access, and they usually do not contain a year-round residence. Typically, they have less than 50 cars daily. The Tug Hill Commission has this in their report. Cornell has this. Minimum maintenance does not mean no maintenance, but rather allocation of your resources based on the community's needs in that road. And so sometimes you'll see that snow plowing services have been discontinued on minimum maintenance roads. You are required, as we had discussed previously under the road standards slides, to keep your roads in a reasonably safe condition for people who are using them appropriately. And it's no different for low volume or minimum maintenance roads. So one of the reasons low volume minimum maintenance roads are important and popular in the Tug Hill region and in other areas is because they're used for snowmobiling and access to recreational property through snowmobiles. But this has been challenged recently in 2 court cases. So the first court case challenged the concept of whether or not local governments had the authority under the home rule law to adopt local laws establishing low volume and minimum maintenance roads. In the first court case, the courts looked at it from a technical perspective and said that the property owner didn't bring the lawsuit in time. You only have so much time to bring certain types of lawsuits. It's called your statute of limitations. They didn't bring the lawsuit in time, and therefore the court said, "I'm sorry, we can't hear your case." They didn't really look at it in terms of the substance of whether or not a town has the authority under home rule to adopt a low volume minimum maintenance road program. The second court case was the same property owner. This time, he looked at the town's own minimum maintenance road program and petitioned the town to have the minimum maintenance road designation lifted. The town went through its local process and decided that it was going to keep the minimum maintenance road designation. Went to the appellate division, and the appellate division said that under the town's own standards, it really should have lifted the minimum maintenance road determination because they had a year-round residence, and you're not supposed to have a minimum maintenance road with a year-round residence. And also the court said that you need to start snow plowing the road. You're required to do so under Highway Law Section 140, and you're not allowed to suspend snow plowing operations except for seasonal limited use roads, which we'll discuss in a minute. So right now, we're not certain what the status of low volume minimum maintenance roads will be going forward. And that's why the legislation is very important to get on the books and passed. So if that's an issue that you're interested in, you might want to talk to your local assembly member or your local senator and about supporting that legislation to move it forward. Okay. So let's talk about seasonal limited use roads. This is a provision in the highway law that came on the books many years ago, and it allows towns to suspend winter maintenance operations, mostly snow removal and ice removal. There are very limited circumstances where we can use Highway Law Section 205-A. The highway superintendent has the authority annually to designate certain types of roads as seasonal limited use. The designation should be made prior to November 1st, and it has to be done annually. The road has to be properly posted in accordance with the Uniform Traffic Control Manual. It allows the town to suspend snow plowing or maintenance on the road between the months of between the time frame of December 1st and April 1st. It doesn't close the road for usage. So if we happen to have a mild winter, folks, could safely utilize that right of way, perhaps that seasonal limited use road. I have been asked the question from time to time whether or not an individual could themselves plow the road. Let's say they wanted, for whatever reason, access to property off of that seasonal limited use road. Could they plow the road themselves? And in conversations that I've had with folks, there doesn't appear to be an answer in the highway law to this question, or even in the vehicle and traffic law. So there's not a statutory prohibition per se. A local government could adopt a local law, perhaps prohibiting private individuals from plowing or treating ice on seasonal limited use roads. And then you would have the enforcement authority of that local law. It's not recommended that folks do this, but unless you've got the local law, it's also not prohibited. And so the seasonal limited use designation is only available on roads that do not have an occupied residence or commercial structure that is dependent upon that road. And there are opinions from the comptroller's office that indicate that that includes seasonal camps. So if you've got a seasonal camp that's dependent upon that road for access, it doesn't qualify for a seasonal limited use designation. I know informally, some towns have worked out arrangements with folks who own camps saying, look, if you're going to be coming up, let us know, we'll plow the road for you. But otherwise, they don't plow the road. But even so, that's not accounted for in the statute. And the comptroller's office has said that you can't designate a seasonal limited use road if it has a residence, commercial structure, or seasonal camp dependent upon it. So some roads have sidewalks, and let's talk about sidewalks for just a moment. A sidewalk is the portion of the street between the curb lines or the lateral lines of the road and the adjacent property lines. It's intended to be used for pedestrians. This is not intended to be used for recreational vehicles or bicycles. A sidewalk is intended to be used for pedestrians. The courts have construed this definition to include the grassy portion adjacent between the curb line and the sidewalk. So there's different roads that might be in a town. You've got town roads, you've got state roads, you've got county roads, some of which or all of which might have sidewalks. So the town law provides for mechanisms to create sidewalks. Sometimes it's done as part of the subdivision approval process. Sometimes it's done independently of the subdivision approval process. The town board can direct the highway superintendent under the highway law to construct sidewalks. There's a provision to create a sidewalk district. Some towns have standalone local laws regarding sidewalks and who's responsible for them. There is a comprehensive discussion of sidewalks in the Red Book, which I should let you know what this is. We offer this called the Red Book for our members. And it's a comprehensive guide for highway management. And there's a discussion in there about sidewalks if you have an interest or an issue involving a sidewalk. In addition, you may have sidewalks on state or county roads. You need the consent of the county if you're looking at constructing a sidewalk along a county road, or the consent of the state if you're looking at constructing a sidewalk along a state road. The state is for state highways. The highway superintendent is responsible for maintenance of all state sidewalks and snow removal, as long as the town board directs them to do so. And the same is true for the county. And again, you want to make sure you have authorization from the county and the state when you're doing anything within their rights of way regarding sidewalks. So driveways and curb cuts. Folks live on rights of way. It makes sense that they're going to have driveways and they're going to need curb cuts. So under the highway law, the construction and repair of approaches to private land to a town highway is under the direction of the highway superintendent, and it's performed by the property owners unless the town has directed the highway department to do this. And some towns have what are called driveway curb cut local laws, or in some cases it might even be an ordinance where they've outlined what the process is, what the cost is, and it's done under the direction of the highway superintendent. The highway department may have a standard type of culvert that they like to be used, or a standard measurement and way in which the driveway accesses the town right of way. If you need samples of that, you could either check those out on the Department of State's website, or you could give us a call. Traffic control. So we've got people using our rights of way. We're going to need to control traffic. First, we're going to talk about speed limits. There's two different groups of towns. Cities and villages, I believe, can do speed limits themselves. For towns, you're in two different classifications. Towns of the suburban class, or towns with populations of 50,000 or more, have the authority to set speed limits themselves on town roads. And that would be done by local law after a engineering traffic study. And then the highway department posts the sign in accordance with the Uniform Traffic Control Manual, and that is a town general fund expense. With respect to all other towns with populations less than 50,000 or of the first or second class, what you would do is adopt a town board resolution. It goes to the county highway superintendent, who then packages it and evaluates it and submits it on to the regional DOT. And the regional DOT makes the determination of what the speed limit will be. And again, that gets posted by the highway superintendent in accordance with the Uniform Traffic Control Manual. Stop signs are a common traffic control feature that towns utilize. This again is another look, it's by local law or ordinance. It should be based on traffic engineering studies. It's a town board action, and then the town highway superintendent will post the sign. You do have a duty to warn folks if it's, if there's a dangerous situation, and the way you do that is with traffic control devices. And this again is also a general fund expense. Still winter in many parts of the state. I know it is here. And sometimes we need to plow snow and we've got cars parked in the right of way. You can address winter parking by local law. And you want to make sure in that local law that you build in the penalty and who has enforcement authority with respect to removing the car if needed. We've got drainage issues that come about. Cornell Local Roads has an excellent drainage manual. It's on their website. If you ever have a drainage question, it's a wonderful resource. And I think they also do individual training classes from time to time on drainage as well. Towns can acquire drainage rights by dedication, prescription, or eminent domain, very similar to the way we acquire our highways. You want to make sure you have a clear meets and bounds description. A deed, an easement, or a survey are very helpful. You want to make sure when you're getting your drainage easement that you also make sure that you have access to your easement when you need to do work. There is a provision in the highway law that does provide the highway superintendent with the authorization of the county highway superintendent and the town board can access private property to do drainage work that is in support of the highway system, even if it's outside the right of way. It's important to work with the property owner and to restore the property to the way it was when you started your work. And if it's absolutely necessary, you can always get a court order. Obstructions. We have a lot of obstructions in our rights of way. Some are permanent, some are temporary. The authority to address obstructions is Highway Law Section 319. 319 includes a laundry list of items that are considered to be obstructions. It could be trees, it could be fences, it could be lamp posts, it could be basketball hoops, utility poles, mailboxes. All of these items can be in our right of way, and they can constitute obstructions under Highway Law 319. Under 319, there is a process if an obstruction in the right of way is becoming a hazard to either highway operations or to people using the town right of way, you can ask that they be removed. So there's two different processes depending upon whether the obstruction is temporary or whether it's permanent. If it's temporary, you have to give them written notice 48 hours in advance. That can be served by mail or personally. And you want to make sure that you're telling them you need to remove the obstruction and what the obstruction is. And they have 48 hours to remove the obstruction. If they don't do so within that time period, then the highway department can remove that obstruction. It has to have been placed there with the property owner's consent. The other type is permanent obstructions, and this is things like utility poles, and they have 30 days to remove that obstruction. And again, the town has to give them notice, and if they don't do so within 30 days, the town can remove the item and charge the cost back to the property owner. The way that the town recovers its cost is set forth in Highway Law 157. The procedure requires written notice to the property owner. You have to provide the property owner with an opportunity to come in and talk to you about the costs of removing the obstruction. And then the costs are levied on the property taxes. So we also have utilities. We talked about them a little bit as being a permanent obstruction. They can be above ground or they can be below ground. Highway Law 149 provides the highway superintendent with the consent of the town board to provide a permit or permission to persons or corporations that want to lay drainage, sewers, and water pipes within the town right of way. And also livestock passages can sometimes be under the right of way as well through Highway Law 149. If you're talking about utility companies, laying gas, electric, cable, broadband, telephone, that's probably going to be a franchise issued by the town board under Town Law Section 64, and that's going to be an agreement, and it's subject to a public hearing. Many towns have adopted road excavation laws. We can get you samples of those, or again, you can find them on Cornell Local Roads website or at the Department of State. And this is talking about how you, as an individual contractor, dig up the town's right of way. Some towns even have dig once policies or open trench policies, where if somebody's opening up the right of way under an excavation permit, anybody else who needs access to the right of way, that's the time to do it so that you're not constantly tearing up the right of way. There's a special provision for water and sewer districts. The highway superintendent supervises their installation, and the cost of restoring the highway is an improvement district cost, not a highway fund cost. And also, everybody has to do the dig safely, the call notification system. So as I had talked about it, we have above ground and below ground. Above ground, it's going to be a franchise agreement. Town board does this with a public hearing. Under most agreements and under common law, the utility company is responsible for relocating their poles to accommodate road work, and they bear the cost. There has been a phenomenon around the state of these double or zombie poles, where the standard is the last user of that pole, the last person to remove their wire from that pole, is usually responsible for taking down the pole. But some utilities are quicker about doing this than others. And so some towns have adopted local laws requiring the manner in which and the time frame within which these zombie or double poles have to be removed. Utility companies are required to file a tree and vegetation management plan with the New York State Public Service Commission. And so you can always take a look at their website. And I've given you the website there where you could access it. And you can always contact them if you want to get one of the utility companies' vegetation management plans. Sometimes we have storms and wires fall down under common law. It's a public safety issue. The electric company has a common law duty to promptly shut off their power and to make necessary repairs and to remove the line that's down. And the telephone company has a similar responsibility, but the courts have said they may have more time depending upon the situation. And you can always get in touch with the Public Service Commission if you have questions about what a utility company's responsibility is to deal with fallen wires. I would be remiss if I did not mention seeker. I am not a seeker expert. There are folks at the Department of State or at the Department of Environmental Conservation who can field technical assistance questions on seeker, but some of these actions may trigger seeker, and you want to make sure you're working with the town attorney's office to comply with seeker where it is necessary. I think I've run a little bit over. I apologize for that, and I appreciate folks staying with me. I don't know if we have any questions, but I'm happy to stick around a little bit longer if there are.
Hi, Lori. Thank you so
Hi,
much.
Jean.
That was a lot of information, and we do have a couple questions.
Sure.
I might have Carl Roser from the town of Ansville. I'm going to ask him to unmute his microphone so he can ask these questions. He's got a couple questions for you. Carl, are you
Hi,
there?
Carl. I think he's still muted.
Yep. Okay, well, I can ask the question that he posted.
Okay.
His first question is, years ago, their town passed a local law in regards to minimum maintenance roads. If they wanted to add new roads, do they have to make a new law or make a motion under the current one? I guess
That's really, I would think that would really depend upon how your local law was structured and whether or not it had a defined list of roads or whether it included a process to add roads. So you really need to go back to the local law that you adopted.
Okay. And they could probably, if they couldn't put their hands on it, they could go to the DOS website and search there and get it, but they should have that on file.
If they don't have a copy on file, all local laws have to be filed with the Department of State. Not all the local laws are on their website. They only go back so far. I want to say they go
Right.
back to the 90s, but I'm
Right.
not 100% sure how far back they go. So if your local law predates when they started posting them on their website, you can contact the Department of State and they will get you a paper copy of the local law that's been filed with them. Also, they should be in the town clerk's office.
Yeah,
The
they
town
should.
clerk's office should have a file of local laws that have been adopted over the years.
Thank you, Lori. The next couple questions has to do with qualified abandonment.
Okie doke.
In our town, if our town deems a road qualified abandoned, is it still considered a town road? And how does that apply to a single lane bridge in that section of roadway? And the second question regarding this is, does a qualified abandoned road have to have signage at each end stating so?
Okay, I don't know the answer to the second question, but it would be in the Uniform Traffic Control Manual. And there's information on that on both the Cornell Local Roads website. They even, I think, have a nice handy guide that they distribute on signage. Or you could get in touch with them and they could maybe answer the question directly for you in terms of what signage might be required. I don't believe there's a signage requirement under Highway Law 205. But there may be one under the Uniform Traffic Control Manual. With respect to whether it's still a town road, it's not. Once it's qualifiedly abandoned, the town loses the responsibility and the right to maintain that right of way. I'm not aware of the statute really looking at the when there's a bridge on the qualifiedly abandoned right of way. I'm not sure if that would come under common law or if there are provisions in the highway law that deal with bridges. It may come under there. If you want to get in touch with me, you can send an email to info@nytowns.org with your question, and I can research that for you if there's a distinction, if there happens to be a bridge on that qualifiedly abandoned road. I don't know that it would change the town's responsibility, but it may change whether or not that road is suitable for qualified abandonment.
Okay. I don't have any other questions. If anyone would like to raise their hand and ask a question directly to Lori, I can ask you to unmute it. Anybody have any other questions for Lori? That was a lot of information. Thank you so much.
I'm so
Lori.
sorry. It's kind of the frequently asked questions of highway topics that I get here at the office. And I appreciate everybody hanging in there with me. I know it was a lot of information.
And just so everyone knows, we are videotaping this webinar. It will be on our YouTube page. And Lori, you were going to send us the outline so we can have that available to anyone that was interested.
Sure.
That'd be great. Well, with that, I don't have any other questions, and I just like to thank Lori one more time for taking the time to do this webinar for us. Thank you very much,
Thanks
Lori.
for having me. It was a pleasure.
Thank
Hope
you,
everybody
Lori.
has a nice night and stays safe.
You too.
Good night.
Good night,
Good night.
everyone.
Anyone on set today wasn't working? Any visitors? Anyone hanging around the trailer wasn't supposed to be?
Sky, who drove us silver Porsche. And they were